As a criminal defense lawyer who works on a lot of murder cases, I get questions all the time about the concept of lying in wait or murder by lying in wait. Lying in wait is when the killer hides his position and waits for an unsuspecting victim and then kills the victim in a surprise ambush-style attack. The classic example is when you go to a man's home to kill him. You hide in the bushes outside his house waiting for him to come out. When he steps out of his front door and starts walking to his car, you leap out of the bushes and stab him to death. Another variation of lying in wait is what the law calls concealment of purpose. Say, for example, that you go and knock on the victim's door pretending to be delivering water. You disguise yourself as a Sparkletts delivery man. You hand the victim a 5-gallon jug of water that contains poison. The victim drinks it and dies of poisoning. Because you concealed your purpose as a means of killing the victim, this would be a form of lying in wait. The significance of lying in wait is that it makes a murder charge a more serious form of murder. In California, where I practice, lying in wait is a special circumstance. That means if it is proven, it makes the person eligible for life in prison without the possibility of parole or the death penalty. At a murder trial, if the prosecutor alleges lying in wait, then the prosecutor has to prove it beyond a reasonable doubt. A good defense lawyer can often convince the jury that there was no lying in wait, and perhaps that the client is not guilty of murder altogether.